Welcome to LawWorks, your local monthly law magazine show where we discuss law-related news and information that you can use. I'm attorney Mike Weber.
I'm attorney Daryl Crossweight. On today's show,
the Law News Docket, where Daryl and I will be discussing the estate planning and probate process, and we're going to discuss several examples of recent estate planning decisions of people in the news. Our guest attorney, Isaac Heintz, will be joining us for that discussion.
The guest docket will feature an interview with our guest who will tell us about his background in estate planning and answer more questions related to the news docket.
And finally, on our resource docket, Daryl and I will give a list of documents that are required when a relative is hospitalized in order to help further their care. Welcome to the Law News Docket, the part of the show where we review law-related stories in the news and how they affect us. It's a new year, and we'd like to start off this year by suggesting that if you have not taken care of estate planning in your family, you really need to make it part of your New Year's resolution. That's our focus today.
A recent survey from Alliance Insurance found that the focus on fitness over finances has been a recurring trend, reaching its point in 2014. 49% of respondents to a survey said that health and fitness was their most important focus area, up from 43% in 2013. And we'd like to offer that taking care of your finances is just as important.
You know, on average, more than 55% of the population will die without preparing a will. Among minorities, the numbers are higher than in the general population. 68% of black adults and 74% of Hispanic adults do not have a will.
Today, we would like to discuss some high-profile examples of estate planning and how to avoid some of the mistakes that many continue to make.
Joining us today is our special guest, Isaac Heintz, who we will interview a little bit later in the show. Isaac, if you can just introduce yourself and tell everybody a little bit about yourself.
Yeah, my name's Isaac Heintz. I've been a Cincinnati resident all of my life. I was born and raised in Clifton. My father, he was in the symphony for over 25 years, and that's what brought him here in the first place. I practice with the Finney Law Firm. I'm married and have two children, a daughter and a son. My daughter just started school, college, and my son is at Fairview.
All right, well, thank you. Let's talk a little bit about estate planning in the news. You know, we've seen several high-profile cases recently. That includes Philip Seymour Hoffman and Paul Walker, among others. You know, are there any mistakes that are going on among the celebrities?
Based on those two that you've just talked about, there were some holes in their estate planning. In Philip Seymour Hoffman's estate, it seemed like a big issue that he had was he only had a will in place when he probably could have used a trust, and probably he could have had some better advice on how to do some tax planning to avoid paying the estate taxes that his estate will end up having to pay. He is obviously a high net worth individual. The average person doesn't have to worry about some of the issues that he had to worry about. If you have under $5 million, there's probably not a concern, especially in Ohio where we have no estate tax, that you'll ever have to pay any estate tax. But with high net individuals like that, when you get on the federal top brackets, you're talking 40%, plus he's in New York and there is an additional New York tax on it too. So I think that they estimated that it would be over $10 million that the estate would end up having to pay in the long run.
And you think that a lot of that could have been avoided?
I think there's planning vehicles that could have been used even beyond just a simple will and trust, like family limited partnerships or limited liability companies, doing some annual gifting that's excluded from your estate. Those types of vehicles could have been used to help him avoid some of the taxes that he's facing. Another issue is not updating his estate plan. That was a concern. Apparently at the time he did it, he only had one son, and it left two of the children unmentioned within his estate plan. I'm assuming New York law is similar to Ohio law, and that they probably have a right to try to get a portion of the estate over to them since they were not mentioned within his estate plan one way or another.
You know what I found interesting in looking through some of the information regarding the Hoffman estate is the fact that he indicated in his will that he wanted his son to be raised during certain times of the year in various cities. I believe one was San Francisco, so that he can enjoy the culture of that particular city. I found it interesting too that the author of this particular article talked about the fact that he could have also put in there that he wanted his children to be alcohol and drug free for them to get money out of his estate. Have you seen things like that in your practice?
Yeah, definitely. With incentive trust, when you have young children or children that are the age of college, a lot of times the parents want to make sure that the assets go to them in a manner that's going to promote their best well-being. Especially with high net worth families, I think one of the unfortunate things that I've seen time and again is that you have beneficiaries of these trusts that are just entitled to things, and it really doesn't help them in the long run. When you tell a kid that they have millions of dollars and they know that from the get-go and they have no incentive to do anything, a lot of times the kids don't turn out well. That doesn't happen all the time, but I've seen it time and again, especially with trust beneficiaries of high net worth individuals. If they know they're going to be taken care of anyway, it does provide little incentive for them to actually take care of themselves. Now, I've seen it on the other extreme too, where you have a very successful parent decide that they don't want their kids to retire anytime soon, so they hold everything back until the child becomes 65, which I'm not sure that really benefits anybody, but it's their stuff and it's their personal decisions to make.
So in a situation like that, they can require that their child finish college, finish their post-college education in order to end up getting anything out of the estate?
Yes, sir.
You know, one of the questions that I see, or that leads to a question, is some of the celebrities, when they pass, the assets are disclosed, and a lot more information comes out on one particular celebrity versus information that comes out that may be very limited on another celebrity. What is used to accomplish that?
Right. I think what you're talking about is a distinction between having a probate estate versus a non-probate estate. In most states, and I think there's certain exceptions, I think I've run into it in Pennsylvania where you actually have assets in a trust that can be disclosed, but in most states I think that trusts are private vehicles that should not come to light in the public forum. Now, if there's a case about it or something like that, then the assets can get disclosed and the terms of the trust can get disclosed if there's a dispute about the trust or the assets within it. But typically, for the average person doing estate planning, trusts are going to be private vehicles. So if the trusts are funded, or they're set up in a manner where your assets are transferred on death to your trust, where they're going to transfer by contract as opposed to through your probate estate. So a probate estate is assets that are in your individual name that don't go by contract or transfer on death designations to another individual. So the will tells you who's to take care of that, that's your executor, and where the assets will go. So with a probate estate, when the assets go through it, you have to account for them and you have to account to where they go. And that's where it becomes public information. And in the cases that you're talking about with Hoffman and Walker, right, those both were probate estate assets. They didn't fund their trust. Well, in Hoffman's case, he did not have a trust. Everything was done by will. And the other one, he didn't fund his trust, so it had to go through a probate.
It seems like they had great intentions, that they met with an attorney or they documented what they wanted done, but it doesn't seem like they then followed up with an attorney to update their estates. Is that pretty accurate?
That is very frequent, and they are not alone in that. A lot of people will have their estate plan and they won't revisit it. Every time that you have a new life event that could affect your estate plan, you should probably review that. If you get married, divorced, something like that, if you have children, if you have a expectation that you're going to receive a large estate from your family, all of those things can affect your estate plan.
You know, one question I also had too is, for instance, I have a daughter who just joined the National Guard. She'll be leaving for basic training here soon. She's 19, but there are a lot of individuals much older who are going to military, that they're deployed overseas. Obviously, it would be in their best interest to also meet with an attorney to develop some type of an estate plan. Do you agree?
I agree with that, but I would suggest if you're in the military to see if you have services through the military that are free, since you're in the military. My understanding is that there are sources within the military that would provide you with that service, so you would not have to pay an attorney. I don't know if that works for people that are only part-time in the military, but I do know for the typical force.
Well, great. Thank you. If you'd like to weigh in on today's discussion, please go to our Facebook page, Cincinnati Law Works. Like us, follow us to get updates for future shows, and feel free to submit comments on anything that we've done. Thank you.
Welcome to our guest docket. Today, Mike and I are going to interview our guest, attorney Isaac Heintz. Isaac, why don't you do us a favor and give us a little background about where you're from, where you went to school, and what you did before you became an estate planning attorney.
Okay. I was born and raised in Cincinnati. My father was in the symphony for over 25 years. We lived in the Clifton area. I currently live in Northside, and I'm involved with the Northside Business Association. I started practicing law around 2001. My graduate and undergraduate are both at the University of Cincinnati. Before I was an attorney, I was actually a social worker, and the last job I had was at Talbert House working with the SAMI population, which was substance abuse, mental illness. There's a lot of intertwinement with the legal system with working with those clients. I would say that my first thought when I was going to practice law was not necessarily doing estate planning. I think that focus came, I went downtown to work at Rennings Fry for a period of time, and that was pretty much all I did down there for that period of time, and it just kept growing from there. And I have a strong background in real estate. I was a title examiner while I went to school, so it kind of fit in because you did a lot of probate review and document review in connection with that.
Why don't you take a moment and describe for our viewers, what exactly is the estate planning process, and what are the different vehicles that can be used to do planning?
Okay. The first step that I would say in the estate planning process is to start to understand who are the participants within your estate plan. Who are the individuals you want to entrust to take care of the actions that you need to have happen. These can be individuals that you're going to appoint as your executor. They can be the trustees of your trust if you're going to have a revocable trust or irrevocable trust. The people that are going to make decisions on your behalf when you're unable to, if you have a power of attorney or healthcare power of attorney. Also think about your assets and what assets you have to deal with. A lot of assets don't necessarily transfer by will or are going to go into your trust. Anymore, a large portion of a person's estate is typically their retirement account or something like that. So you have to think about who am I going to designate as the beneficiary of my retirement accounts, your IRAs, your 401ks, etc. Also, get together addresses, phone numbers, and all that type of thing. That's the type of information you want to have before you go to your attorney so that you have an idea of where you're going to start.
And then from there, we had talked about wills, we had talked about trusts. Are those the only vehicles that are used in estate planning? And describe kind of for our viewers what those are too.
Right. There are multiple vehicles for estate planning depending on what you're trying to do. For high net worth individuals, there's a lot of different pieces of the puzzle that come into play. There's things like the irrevocable life insurance trust, which can create a fund to borrow or to buy assets from your estate to help pay estate taxes if that's going to be implicated. There's items like family limited partnerships where you can control business assets while still giving gifts to your children of an interest in the entities during your life. Trusts can be revocable, irrevocable, depending on what you're trying to do. They can be defective, so that all the income taxes to you, or they can be isolated where they're going to pay their own income taxes and do their own thing. Wills are basically the vehicle that decides how your assets are going to be transferred through your probate estate. And the probate estate is the assets that are in your individual name that do not transfer by contract or otherwise.
Now, when you talk about contract, you're talking about, for instance, insurance policies?
Exactly. Insurance policies, transfer on death designations on your bank accounts, joint survivorship, that's another type of contract or relationship that you can have that can avoid probate but have your assets transfer outside of probate.
Now, when we talk about probate, a lot of people know that there is a probate court. Is it costly to get involved with probate court?
I tell my clients that the best probate estate is no probate estate. But that being said, probate court is not as bad as some people make it out to be. It does add cost, it adds delay, and it does disclose the information as far as your assets and stuff that go through your probate estate to the public. For instance, if you pass away in Hamilton County and you wanted to find out and you were nosy about your neighbor, you could look them up on their online site and get a complete list of all the assets that went through probate, and also figure out who the executor were, who the beneficiaries were, and stuff like that. So it's not, one thing it is not a private process.
And when we talk about the probate process, I know that there is testate succession and intestate succession, correct? Can you kind of explain that for our viewers?
Testate succession, what you're talking about is if you die testate, you die with a will, and the will decides how your assets are going to go. If you die without a will, then you die intestate. You die without a will. And if you die without a will, your assets are going to transfer by the statute of descents and distributions. Generally, if you're married, it's going to go to your spouse a majority of the time, depending on how much you have. If you have children outside of that marriage, then your other children also will get a share of that. If your spouse is not there, then it's going to go to your kids or their kids. And if they're not there, then it's going to go up to your parents and then back down to your brothers and on and on.
You know, we've seen some well-known figures that don't have proper wills, proper trusts, or or they don't have those at all. How do you? Why does that happen?
I think a lot of it is people don't like to think about passing away and trying to plan for the future. You know, I can't speak as to the individuals, but I have seen a lot of clients come into my office who you would think would have the estate planning done, and they don't have it. And all I can say is they're doing it now, and that's a positive step.
When and how do you pay the taxes related to estates?
Well, keep in mind that at this point in Ohio, unless you have an estate in excess of $5.4 million combined with your spouse, you don't really have to worry about estate taxes at all. So that's for the average person. I think estate taxes are no longer an issue right now. Now, of course, they could change the laws. Who knows? But
so if you're under $5.4 million, let's say you have a gentleman with a $750,000 estate and he passes away, would he be looking at costs in probate or for taxes?
there would be no estate taxes on an estate that size.
When you are getting information together for a will, just a regular person, and unlike some of the people that we talked about earlier, should you have relatives that or will be the guardians of your children or the trustees, and can you have people from out of state, or what do you recommend in a situation like that?
My recommendation is use the people who you feel are going to do what you want to have happen. So if that's your friends, if that's your family, that's wonderful. But it's that person that you trust to see your final wishes through.
Now, we've also talked about trust. Can you define for our audience the basics of a trust, how it works in estates?
Right. I think what we're typically talking about when we're talking about estate planning is a revocable written trust. So an agreement where a trustor or grantor establishes a trust and appoints a trustee to deal with the assets that are subject to the trust. The trust should determine who the trustee is and how the assets are going to be distributed. With a trust, you can be very creative and you can control a lot of what's going to happen with the assets in the trust. Especially with young children, even if you're of modest means, a lot of times a trust will be an important vehicle that you can use to help preserve the assets for a period of time. Obviously, if you have a young child that's 19, you probably don't want them to get a couple $100,000 if both their parents just passed away.
Power of attorneys. You have the durable power of attorney for health care and for finances. Is that correct?
That is correct.
When do they take effect?
Well, it depends. That's a good question. There's two different ways to have it done. With the healthcare power of attorney, the healthcare power of attorney is typically going to take effect when you're unable to make the medical decisions on your behalf. The question, though, with the financial power of attorney is whether or not you elect to have what's called a springing power of attorney or a standing or durable power of attorney. A durable power of attorney or standing power of attorney is a power of attorney that's in effect as soon as you execute it, and that individual or the individuals listed within that power of attorney are going to have the right to have whatever financial decisions are listed within that document and to make those decisions on your behalf. A springing power of attorney requires a condition precedent prior to it becoming in effect. My personal preference is the standing or durable power of attorney, and I leave it to the clients to make that decision. My concern with springing power of attorneys is coming up with a standard that's very clear that has it go into effect. I'm concerned that when you go to the doctor to ask them to write a note that you're incompetent or that you're unable to handle your financial affairs, some medical professionals, depending on what the issue is, are going to be hesitant to write that note. And then you could be back in the situation which you're trying to avoid. The option to the power of attorney is having to go to probate court and have a guardian appointed of the estate and of the person, which is what you would like to avoid by executing the power of attorney in the first place. And one key I want to point out is this is a common misconception, but powers of attorneys terminate as soon as you pass away.
Well, Isaac, thank you very much for joining us today and sharing this information. We really appreciate you being here. Please stay tuned for our resource docket next. Welcome to the resource docket. Today, Daryl and I are going to discuss something that's very, very important. In the last couple of years, both Daryl and I have had people that are close to us go into the hospital. What we're going to talk about are a list of items that are required for caring for somebody when they're being admitted into the hospital.
You know, one key item is a list of medications and allergies that your relative may have for various medications. This is important to present as soon as possible when they are admitted into the hospital in order to avoid any possible drug or allergic reactions. You know, typically the older generation usually have more health problems and take more medications than younger people. Because of this, they're more likely to experience, dangerous drug interactions. You know, every year, 1 in 3 adults, 65 or older, has one or more adverse effects as a result of medications.
Most hospitals have this information on file, probably, especially if you're in a health network. However, due to HIPAA laws, which restrict health information in order to protect privacy, you have to provide this when registering a patient. They may or may not have access to previous entries due to these protections.
You know, a list of physicians is also important. A lot of older individuals unfortunately treat with numerous physicians. One physician may not know the other physician is treating your relative. If they don't know, it's more likely than not that the hospital's not going to know. You know, it's easy to try to keep a list of these. You can, place that list on your cell phone. My mother has a list in her purse. My sister and I both have lists that if she's admitted to the hospital, we can provide that to the hospital so that they have a complete understanding of who she's treating with and what she's being treated for.
You absolutely, positively have to have the medical insurance and prescription plan identification numbers. It's probably even better to have copies of the actual cards. You also have to have the Social Security numbers so that the hospital can have those.
You know, another document that is extremely important when someone is hospitalized is a durable power of attorney. That is the legal document that gives someone the authority to handle your legal and financial obligations while you're hospitalized. It's also important to have a healthcare proxy. That is a legal document that gives someone the authority to make decisions for your parent or elderly relative. In most cases, your hospital will register you for this prior to being admitted or for a procedure. It's best to have this completed before you're hospitalized. Since you don't know when you're going to be hospitalized, it's just good to go ahead and have it done right now.
Another thing to consider is a DNR, which is also a do not resuscitate, and an elderly relative can make informed decisions in writing before anything happens about what they want to happen if they have a critical situation. It's also important to have basic financial records, a list of assets, account numbers, names, and contact information for financial advisors or bank representatives in case they need to be contacted.
And a really important list to have and to provide is a list of contacts, a list of family members, children, grandchildren, close friends that you might want to be contacted in case you are hospitalized. And unfortunately, if it's terminal and you become very ill, a list of clergy members that you can contact while you're hospitalized.
Great. Thank you very much, Daryl. Thanks to our special guest, Isaac Heintz, and thank you for watching.
Check out our Facebook page, Cincinnati Law Works, like us, and follow up for more information regarding future broadcasts. Also check out our YouTube channel page, Cincinnati Law Works.